Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning.
Case number 20-1335. Natural Resources Defense Council petitioner versus Michael S. Regan, Administrator, U.S. Environmental Protection Agency and Environmental Protection Agency. Ms. Ford for the petitioner, Ms. Buckley for the respondent, Ms. Snow for the intervener.
Thank you. And we are ready to hear our first case this morning. Ms. Ford.
Good morning, Your Honors. May it please the court, Sarah Ford presenting on behalf of petitioner NRDC. I'd like to reserve 3 minutes for rebuttal. Your Honors, drinking perchlorate can cause permanent and irreversible harm to the developing brains of fetuses, infants, and children. Nevertheless, EPA has decided not to set limits on the amount of perchlorate in drinking water and not to require public drinking water systems to test for it or inform people if it's found in their water. We challenge that decision on a number of grounds. I'm of course happy to answer any questions the court has today, but I'd like to focus my arguments on the reasons that it's arbitrary and capricious because it's not supported by the record and is inconsistent with the Safe Drinking Water Act.
Now, let me just ask you a preliminary question to that. If we determine that the agency does not have the power to delete the rule in the first place, do we need to answer the other questions?
Your Honor, I don't believe the court needs to answer the other questions in that.
Fine, thank you.
Why don't you just say a few words about your statutory argument first?
About the statutory argument? Sure, Your Honor. EPA is a creature of statute. It has only the powers, in this case, that the Safe Drinking Water Act grants it, either explicitly or implicitly. And it's clear here from the text, structure, and purpose of the argument of the statute that EPA didn't have the authority to reverse a regulatory determination that it made 9 years prior. To begin, you see that in the text. The statute says not once, but twice, that once EPA makes a regulatory determination, the agency shall regulate. The second time, the statute sets out a clear deadline by which EPA has to do that. It has 24 months to propose a standard and then another 18 months to finalize the standard.
But does it say that the EPA can't withdraw a determination or can't change a determination?
Well, Your Honor, it certainly gives clear textual commands that the agency can't do so 9 years after the...
Where's the textual support for that?
Because a standard is due within, in this case was due by 2014 at the latest. And once a standard is in place, there's an anti-backsliding provision that protects against it.
But that's once there's a regulation. They actually didn't promulgate a regulation.
You're right, Your Honor, because the agency has failed to comply with the Safe Drinking Water Act. They've missed that deadline.
Correct, but anti-backsliding doesn't apply unless there's already a regulation.
No, Your Honor, but so a statute can prohibit.
Wait, do you agree with that?
That the anti-backsliding provision, I agree that there is no regulation in place right now.
No, wait. Do you agree, because the government, the EPA says this too in the brief, that the anti-backsliding requirement isn't triggered until there's a final regulation?
Your Honor, I think the statute says that the anti-backsliding provision applies once there is a regulation. However, it's clear from the text of the statute that the Congress expected there would be a binding regulation in place within 3.5 years.
That's a different argument. That the anti-backsliding provision says any revision of a national primary drinking water regulations shall be promulgated in accordance with the section, except that each revision shall maintain or provide for greater protection of the health of persons. It specifically deals with regulations. So anti-backsliding does not apply to a determination to regulate, correct?
Yes, Your Honor, I agree with that. Right. However, there are a number of other provisions in the statute that indicate that Congress meant for the agency to take 2 steps in deciding whether to regulate. there's a ton of process that precedes a determination to regulate. And that is the stage at which EPA is tasked with deciding whether to regulate. And the agency has a ton of discretion in that. It gets to pick, by consulting with the scientific community and the SAB, which contaminants it's going to focus on.
So I understand that, but it seems that the same amount of thought and process went into the decision to withdraw the determination. It seems that, yes, there is a framework put in place for a two-step process, which involves a lot of thought and care and research. But it seems to me that this statute doesn't say that you can't withdraw a determination or change your determination. And in this particular case, it seems that the decision to withdraw or change the determination also was accompanied by thought and care and regulation, although perhaps not as much thought and care as they should have put into it, which I'd like to hear more about. But in terms of just the agency's ability to withdraw a determination, I don't see where in the statute, in the text, it says they can't do that. Whether they did a good job of that is something I definitely want to hear about. But just can they do it? It seems that they can.
Your Honor, we believe that Congress, in setting out the structure, was trying to demarcate two specific steps to the regulatory process. And there's a reason for that, right? Congress was trying to do multiple things in the 1996 amendments. It is true, as EPA and AWA say, that Congress was trying to protect against any truly inefficient regulations. But Congress was also trying to force an agency that had been recalcitrant in issuing regulations to regulate. It was saying, go through a bunch of process, make a determination. But once you made that determination, we're going to hold you to it. You need to issue regulation.
Didn't they change their determination in this case? Because they previously determined not to regulate
That was
chlorate.
a preliminary determination, Your Honor. They made a preliminary determination as the statute calls for. They took public comment as the statute calls for. And then they made a final determination as the statute calls for. The statute is clear of what the agency is supposed to do after that. And it's not to flip-flop back and forth on that regulatory determination. In fact, the statute says, consult with the Science Advisory Board, but under no circumstances is that to delay your promulgation of a regulation. Congress knew that the agency would continue to consider the science and nonetheless wanted to hold the agency to the clear, unequivocal command, you shall issue a regulation.
What's your answer to EPA's argument that if you're right about this, they lose, the agency loses all flexibility to adapt to newly discovered evidence or better, best evidence, and that they're locked in by the anti-backslide?
Your Honor, that's simply not true. The statute provides for a number of off-ramps. Now, I think it's understandable to be concerned about what is the possibility. What if there's truly a scientific breakthrough and we realize this isn't a problem at all? That situation is vanishingly unlikely.
Well, suppose it happens. Let me give you an example. Suppose, for example, after 10 years of regulation for various economic reasons, the contaminant is simply no longer being produced.
After 10 years of regulation, the anti-backsliding provision would be in place. So it's clear that science isn't, Congress knew that there might be situations.
But there's no more, the contaminant's no longer being produced. In other words,
sure, the statute provides a number of off-ramps.
The anti-backsliding provision wouldn't, the EPA said they would not be able to change the standards.
They would not be able to weaken the public health protection. That's true. They could change monitoring requirements to reduce the burdens on water systems. States can issue variances for systems that can demonstrate that they're unlikely to have the drinking water, to have the contaminant in their drinking water system. There's a number of other off-ramps that the statute provided to deal with that situation. But even if the court is not convinced by our statutory argument, the way that the agency undertook this decision here is not consistent with the Safe Drinking Water Act. And I'd like to start by explaining the problems with the levels of perchlorate contamination that EPA selected as its levels of public health concern. Now, let me just pause for a minute and explain why the maximum contaminant level goal standard is relevant to this case. We're not arguing that the Safe Drinking Water Act requires EPA to set a level of public health concern that meets the maximum contaminant level goal. But this court reviews an agency's action on the basis and the rationale that the agency provided in the record. And here, if you look at the final decision document, specifically if you look at 85 Fed Reg 43995, EPA equates the levels of public health concern with the maximum contaminant level goal standard. The agency says, we are selecting as our levels of public health concern the 3 levels that we proposed as maximum contaminant level goals. And if you want to find our rationale for how we selected those numbers, look at a technical supporting document that we issued at the time of the 2019 regulations. And if you look at that technical supporting document, and I'm looking particularly at JA 373 and JA 415, it is very clear that the agency selected these levels because it believed they would avoid any adverse health effect. So either there is no basis in the record that explains how EPA selected these levels, or the basis that the court has with which to evaluate these levels is the level that EPA explained, which is the level that's set for maximum contaminant level goals. Here, the thresholds that EPA set do not meet that level. EPA selected 3 potential levels of public health concern, all of which correspond with measurable decreases in the average level of IQ across the sensitive population. IQ loss, whether it's 1 point or 2 points or 3 points, is an adverse health effect. That's clear from common sense. You can imagine a doctor prescribing a medication to a patient, and they would never tell the patient that this will have no adverse health effects, knowing that there is a population of patients who would suffer on average 1 to 3 IQ points loss. And those losses are very significant when you look particularly at the ends of the bell curve of IQ, of particularly low IQs and high IQs. It has significant impacts for those populations.
Is it your view that the MCLG has to be 0? Is that the level of the chlorate has to equate to a 0% drop in IQ, or can it be 0.5 or?
It has to equate to no adverse health effect. So I presume there is some level of IQ loss that will not be measurable on a population level. And I certainly think EPA could set a level if there's no measurable IQ loss.
Do you know what that level is in terms of parts per billion?
I don't, Your Honor, because there's nothing in the record that establishes that level. What the record establishes is that it's not 18, 56, or 90. Your Honors, I see that I'm into my rebuttal time. So if the court doesn't have any further questions at this point, I'll reserve my remaining time.
All right, that's fine. Thank you. We'll hear from Ms. Buckley.
Morning, Your Honors. May it please the court. Sarah Buckley from the Department of Justice on behalf of EPA. With me at council table is Pooja Parikh from the Office of General Counsel at EPA. I want to first address briefly EPA's authority to withdraw the regulatory determination, and then address why EPA's technical analysis was a rational exercise of its technical scientific judgment. This court has long recognized that agencies have the power to reverse course and change position.
Wait, let's just, before you get into that, to me, as I read your brief, the brief argues that the agency has inherent authority to do this, right? That's what, in fact, your brief mentions the word inherent authority, I think, 13 times. But this court has made quite clear that agencies don't have any inherent authority. That authority has to come from a statute, either expressly or implied. So the question before us is, where in the statute does the agency have the authority to withdraw? Do you agree with me that that's the question?
Yes, Your Honor. I would say that this court has characterized the power to reconsider a decision as inherent authority, as inherent in the power to decide the
No,
question?
no, I don't think so. I think agencies have implied authority to change or withdraw a regulation when the statute permits it or when the statute's silent and there's an ambiguity there. But I don't know of any case that says that, any recent case which says that agencies have inherent authority to change a regulation. They only have the authority that comes from the statute. And all the cases you cite here, every one of them, including Fox Television, they are all cases where it's a generic statute. Agency issues Congress directs the agency to regulate, and there's no precise provisions about when and under what circumstances that are listed in this statute. They're totally different statutes. So you're not going to get anywhere by citing cases that rely on different statutes. It seems to me the agency to prevail here, and you might, but you have to point to implied. You agree it's not express, but so you have to point to implied statutory authority. And the question I have is, where does that come from?
Well, Your Honor, I think that it is implied by the statutory structure and the text that Congress provided for when EPA can make the determination and what factors it has to rely on. Congress made clear that the determination of whether drinking water regulation is worthwhile when EPA has the authority to regulate depends on several factors, including whether in the administrator's sole judgment,
Right.
there's a meaningful opportunity for health risk reduction.
The statute
Right.
says, you go ahead.
I'm sorry, let me just finish my sentence. You're absolutely right. And if you look at the statute carefully, that's basically the only place where Congress has given the agency any discretion. It says if the administrator makes that determination and sole judgment, you're right about that. But there's no other discretion here. It says that once the determination is made, the agency, it says shall regulate, and then it says shall issue the regulation within a specified number of years, and then shall issue the final regulation. So it says shall 3 times there. Elsewhere it uses may, so Congress clearly knows the difference. So I guess I don't see where the implied discretion to withdraw a regulation comes from.
Well, in 2 other places of note in statute itself.
Mm-hmm.
First, the fact that Congress expressly makes a negative regulatory determination not to regulate, judicially reviewable, and does not do the same for a positive regulatory determination.
I'm not sure that helps your case.
Well,
in fact, I actually think it hurts your case.
Well, Your Honor, I think
because Congress is basically saying no reason to review the determination because it will end up in a regulation which will be reviewed then.
Right, Your
Doesn't
Honor.
that make sense? I think that hurts your case.
Well, Your Honor, to try to change your mind on that,
Sure, try.
we would be left in the anomalous situation that the only way to address an error or a change of circumstances that is relevant to the factors that Congress gave EPA would be on judicial review of a regulation that EPA has.
Well, is that really right? You mentioned 2 things. You mentioned an error and a change in circumstances. Okay, so let's take the error. First of all, there's 2 sets of notice and comment rulemaking and judicial review, right? Over the initial determination. So it's pretty unlikely that an error is going to creep through there. It seems to me quite unlikely that would ever happen. Your stronger argument is future developments, right? Change circumstances, better research, correct?
Yes, Your Honor.
But I don't see why the agency doesn't have the authority. You say in your brief you can't have less stringent regulations, but that's not what the anti-backsliding provision says. It says that you have to maintain the level of protection. And it seems to me that if there's new research which shows that a less stringent standard would, quote, maintain existing health protections, that the agency can change it. There's nothing in the statute that would prohibit that.
Well, Your Honor, the statute would continue to apply no matter what monitoring and record keeping requirements, which do impose a cost on public water systems. And in fact, those kinds of monitoring requirements for contaminants that are very unlikely to be there is the concern, one of the concerns about costs that motivated the 1996 amendments that's discussed in the Senate report. So if EPA is forced to go to regulation, even when new information or a more sophisticated analysis, as was done here, demonstrates that the contaminant is not actually present at levels of public health concern with a sufficient frequency, then EPA would be forced in the position that Congress expressly said it was trying to avoid.
But it wouldn't, you're talking about the anti-backsliding provision, right?
Not only the anti-backsliding provision, Your Honor, but the regulation would necessarily include monitoring. So the anti-backsliding.
Well, doesn't EPA have authority under the statute to provide exemptions for monitoring?
Yes, Your Honor, but only after several years of initial monitoring for the public water system to then demonstrate.
And also, what do you think about the provision that says, okay, so it says shall issue regulation, shall issue within specified number of months. And then it also says the agency, shall review and revise the regulation every X number of years, right?
That's correct.
It doesn't say, by the way, it says shall review and revise. It doesn't say, does it, revoke?
It does not say that the agency can revoke a regulation, but this regulatory determination is a preliminary step on the road to regulation. And so the fact that the statute speaks expressly about the national primary drinking water standards and what EPA can and cannot do with respect to those once they're promulgated implies that there is more discretion and the power, the implicit
But in this
authority.
particular statute that we're concerned with here, Congress says if that first determination is made, then EPA shall, right? EPA has to regulate at that point, right?
Yes, Your Honor.
Now, once that's done, there is nothing in the statute that says then they can do away with the regulation, right?
That's correct.
And Congress's apparent purpose, you can consider the purpose of the statute is to make sure that contaminants that have that are past that first step are regulated, are regulated. So that would be fair to say, wouldn't it?
Your Honor, I would amend that to say it's fair to say that Congress was very concerned with regulating where the administrator determines that there's a meaningful opportunity for health risk reduction, and that the change in statute from a system prior to 1996, where EPA was obligated to regulate 25 new contaminants every 3 years, to one that moves that into a discretionary determination where the agency.
I'm having a hard time getting that moved into a discretionary determination. I do not understand why statute doesn't seem to say if that threshold is passed, then you shall regulate. And in this case, for example, you say, well, in 2 states, they were able to reduce it, so therefore we take it away. Congressman doesn't seem to have wanted that. They did not give you the authority to do that. And I'm like Judge Tatel, I'm not sure there is an inherent authority. I'm not sure there's even an implied authority here to do away with the regulation that Congress told you had to put there.
Well, Your Honor, in similar circumstances, such as New Jersey versus EPA, where the court has assumed that EPA would have the authority to undo a decision, except if there is another mechanism capable of rectifying the error.
Mm-hmm.
And in that case and in others, it is only where EPA did not follow the process that Congress had set out.
Yeah, but Congress didn't set one out here, right?
That's right, Your
If I
Honor.
can
So that
inquire,
could be an indication that Congress didn't want one. Congress did not want a way out. I mean, I hate to suggest this, but the lawmaking branch of government is the legislature, and if they chose to change that, they could. But at this time, they didn't put it in there that the agency could do it for them. I'm not sure where it's coming from that they have an implied authority to undo what Congress told them they had to do.
so if you look at the statutory language, what triggers the obligation to regulate, shall regulate, is the determination.
That's correct.
You make a determination, then you shall regulate. But if before you actually promulgate, you withdraw the determination, or you change the determination, is there still a duty to regulate based on the withdrawn determination?
It's EPA's position that there is no longer a duty and in fact no longer authority to regulate.
So I think that the statutory language does seem mandatory. Once there's a determination, you shall regulate. But there is nothing in the statute that says that before you've actually promulgated, if you withdraw the determination or you change the determination, that you still have to regulate according to a determination that has now been withdrawn.
We agree, Your Honor. And this court has never found that the existence of a deadline in a statute is a reason to indicate that the authority to reconsider a determination is abrogated. And this court has also not seen that language such as shall abrogates that. In the Idaho Conservation League decision, the EPA's prioritization, the deadline was 26 years prior, and the court still affirmed that EPA had the authority to determine not to issue regulations if that's what the record before the agency demanded. And here, I think it's important that we're not in a situation, an extreme situation that could arise, and that NRDC's position would hold EPA is incapable of rectifying a clear error, like a study that the determination was relied on is retracted, or there's a computational error.
I understand that. And I'm just wondering if the statute does not speak to whether a determination can be withdrawn or changed prior to promulgation, is the agency entitled to any deference about that?
Deference in interpreting whether it has the power to withdraw.
To withdraw or change a determination before promulgation.
I think the agency would be entitled to some deference, Your Honor, but I think it's the clear best reading of the statute and clearly in line with this court's precedent about agency's reconsideration authority.
Let me make sure I understand your question to Judge Van's, your answer to Judge Van's question. You're saying that it requires no deference on our part to accept your argument that the agency can withdraw a determination anytime prior to issuing a regulation. That's clear in the statute? Is that your point? I'm not challenging you, I'm just asking you. In other words, in the old days when we had Chevron, we used to talk about Chevron 1 and Chevron 2. Is this clear as far as you're concerned? Or is this something we would have to defer? We would have to defer to the agency's judgment.
I think it is clear, Your Honor.
And where does the clarity come from? Tell me.
It clearly comes from the implied elements of the statute that we've discussed about the factors EPA is to apply, the judicial review provision, the anti-backsliding only attaching after a regulation is promulgated. But it is also clear from this court's precedent about the power to reconsider, the power to reverse course being implicit in, if not inherent in, the power to decide in the first place.
So if I were to think, maybe EPA is right about this. Maybe it does have the power to withdraw before it regulates. I'm not saying I do, but if I did, but if I don't think it's clear, that is, if I think it's an ambiguity in the statute, what would we do there? You don't claim any Chevron deference in your brief.
That's correct, Your Honor. We didn't raise that argument.
So what would we do?
I think you should deny the petition for review.
Well, we can't. You haven't claimed Chevron deference, and I think the statute's ambiguous. I'm not saying I think it's ambiguous. This is my hypothetical.
I understand.
Yeah.
I cannot think, I'm canvassing the cases that I can remember in my head, Your Honor, and I cannot think of another case that involved this implicit or implied agency authority to reconsider, resting on the agency's interpretation of its statute.
Is there some reason why you don't want to rely on Chevron or ask us to defer to the agency? I'm just wondering.
Well, Your Honor, I'm not sure that in the agency decision itself, Chevron or the agency's interpretation was invoked. The agency discussed the reasons that I've laid out for you today as its interpretation of why it had the authority. So I suppose Yes, without invoking Chevron by name, the agency certainly offered an interpretation of the statute. And to the extent that you think that the statute is.
Maybe you just don't want to sign in, decide NRDC versus Chevron because NRDC lost that case.
Oh. Well, you know, I'm trying to stick to the arguments that we advanced in our brief and grounds that the agency set out in their regulation. I apologize, I'm talking around it, but I guess,
But
yes.
is Chevron waivable? Chevron deference is not waivable.
No, Your Honor, it's a interpretation canon, interpretive canon. In any event, just to briefly touch on the merits of the decision here and to explain what EPA did from a technical standpoint, I think there's two parts to this analysis. First is the legal question of what target was EPA shooting at in this analysis. And I think it's clear from EPA's preamble here that it was making a determination about the levels of public health concern. Yes, it relied on a health effects analysis that was developed for the purpose of setting an MCLG, but it never finalized a regulatory determination that those were the levels that met the MCLG standard. Its final action here was applying that health effects analysis, knowing what we know about how perchlorate actually leads to adverse effects, that it is not present in public water systems with a sufficient frequency at levels of public concern. And then on the underlying merits of that technical analysis, EPA rationally and at the behest of the Science Advisory Board developed a state of the science cutting edge model to, for the first time, connect the literature on iodide uptake inhibition.
So I find it really surprising and disturbing that the EPA proposed a MCLG that is associated with a 2% drop in IQ in the sensitive subpopulation. And the definition of an MCLG is a level at which no known or anticipated adverse effects on the health of persons occur and which allows an adequate margin of safety. How could the agency possibly find that a 2% drop in IQ has no adverse effect on the health of persons?
The question boils down, Your Honor, to a data interpretation question. For this type of modeling, biologically based dose response modeling, the way that you interpret whether you are observing an effect from the contaminant is to look at a relative change from the mean. As EPA's benchmark technical dose guidance said, a range of those relative changes from the mean have been used. One standard deviation, 10%, or data such as here, data from epidemiological studies, 1%. EPA considered the range, proposed the range of 1% to 3%, and in the end, finalized the determination that it does not appear with sufficient frequency at levels of
I still don't understand, because it still boils down to a 1% to 3% drop in IQ and a finding by the agency that this is not an anticipated adverse effect on the health of persons. And if we think that that's arbitrary and capricious, you would lose on the merits of your exercising authority if we find that you have the authority to change this.
Yes, Your Honor. I think that the important point is that this is a data interpretation exercise. That when you have a continuous outcome like IQ, and you're using a model such as this, you have to be sure or have some degree of certainty that what you're observing is not natural variation, but you're observing the effect of the contaminant. And it's the relative change from the mean that scientists use to determine whether they're actually seeing that adverse effect. That's consistent with the technical dose guidance. And as you heard earlier, NRDC hasn't been able to identify in the record anything that would have supported EPA using a lower level.
So these levels of perchlorate are associated with drops in IQ, 1%, 2%, or 3% drops in IQ. And you do not look, and there's nothing in the record, as we just discussed with opposing counsel, about a lower level, which would be associated with no drop in IQ, which would seem to fit the statutory definition of MCLG. So if you didn't consider that, how is your action not arbitrary and capricious?
Well, Your Honor, because the approach to defining the adverse effect, there are multiple approaches that one can take. One could take a no adverse effects level approach. That is, as I understand it, a technical way of interpreting data using different tools than here.
Is that statutorily required by the definition of an MCLG?
No, Your Honor. Our position is that the statute does not dictate what particular technical approach EPA has to take.
No, but it has to have no anticipated adverse effects on the health of persons.
I understand, Your Honor. There's
Statutorily.
Statutorily, correct. And EPA attempted to design this model in order to set that level. Its multiple peer review panels determined that its model was fit for purpose for doing that. And when you have that kind of model.
But I'm not reviewing fit for purpose. I'm reviewing whether you've met the statutory definition of an MCLG, which based on the record, it seems that you have not.
Well,
And then you equated that with the standard to regulate. You equated it with the standard for levels of public health concern.
Your Honor, the statute contains two legal standards there for EPA to interpret health effects.
I understand,
right?
but you equated them.
What EPA did and what EPA said was that it used the public health effects analysis that it did admittedly create for purposes of setting the MCLG, and said that, well, at those levels, even at our most stringent proposed MCLG level, not defending that as the MCLG.
At your proposed level, but there could have been a lower one.
Your Honor, the agency put those levels out for public comment. There is no public comment supporting using a smaller than a 1% relative change from the mean for this purpose, for this technical purpose. And part of the reason why EPA had to use this particular model is that there is not, in fact, literature that directly says that perchlorate causes adverse neurological developmental effects. What we have is a literature that connects perchlorate to iodide uptake inhibition, which both the National Research Council and the Science Advisory Board told EPA is a precursor to adverse effects. So when EPA brought this problem of how should we set an MCLG to the SAB in 2012, the SAB recommended that EPA develop this kind of model in order to actually connect that literature to the other existing literature, which was how does thyroid disorders and iodine insufficiency relate to neurodevelopmental effects. So EPA developed the model to connect the two literatures for the first time to actually connect perchlorate to adverse effects. And it did so because it needed to meet that statutory standard. It didn't believe that relying on the health reference levels that it had used for the 2011 determination and before, which again focused on iodide uptake inhibition, would support a determination under the statutory standard for an MCLG. In doing that, EPA then found, for reasons that include the body's ability to generate other thyroid hormones to make up for an iodide deficiency, that the actual level that would be associated with adverse neurodevelopmental effects in the sensitive subpopulation was higher than what they had considered based on the health reference levels from iodide uptake inhibition. And so given that conclusion and using the interpretive questions there, EPA then said, well, our levels of public health concern, that's different text than the standard that applies to the MCLG. It substantively means something different. We think it means it's flexible. We think we have used health reference levels before. And we think that given the data before us, that this contaminant is not present with a sufficient frequency at levels of public health concern, and that we lack the authority to regulate it.
So I'll just say that you seem to be trying to rely on this model, which is subject to criticism from the scientist amicus brief. But the bottom line is what you came up with is a level of perchlorate that is associated with significant drops in IQ level. And there's a statutory standard that talks about adverse effects on people, and I don't see how that fits. And then in the regulation, it says EPA used these potential MCLGs as the levels of public health concern. And so if you're going to equate these MCLGs that do not meet the statutory standard with the levels of health concern, it seems that you have not properly performed your function. Because there's, in my view, clearly an error in terms of setting perchlorate levels that allows what appears to me a significant adverse effect on persons, and therefore does not meet the statutory definition of an MCLG. And so I feel like the agency is trying to hide behind a screen of this is highly technical, we used a model, and saying that that should be enough. And I don't see how that fits the statutory regulatory standard.
I understand your art, and I won't belabor it much further. I will say that, again, there are two questions here. What is the standard that applied to EPA's action? EPA did not finalize this as an MCLG. I'm not here to defend the agency's MCLG decision because it did not make one. Instead, it determined whether or not this contaminant was present at levels of public health concern and whether it presents a meaningful opportunity for health risk reduction.
But you define the levels of health concern based on these MCLGs, and you don't know anything below the 1%. We don't have information except about these MCLGs because that's how you define levels of public health concern.
And then again, Your Honor, I think the definition of the levels of public health concern were at the levels that were also being used for the MCLG. But that is an underlying scientific analysis, not unlike the health reference levels that were used before, that EPA could then apply to the statutory mandate it was given. So there's an underlying body of scientific evidence, and EPA applied the statutory standard to making its regulatory determination. In addition, on just the technical point underlying, I think it's important to note that not only one, is this consistent, is using a relative change from the mean consistent with how you interpret data in this kind of model, but that EPA built additional conservative assumptions into that model. First, in defining the sensitive subpopulation as the thyroid deficient mothers, first trimester mothers, the offspring of those thyroid deficient mothers, and built in a number of extremely conservative assumptions about those mothers, thyroid function, iodide intake, and TSH loop. Once after applying the literature to that, it applied additional conservative assumptions about how much those individuals take in chlorine in their drinking water versus their food, their body weight, et cetera. All of those conservative assumptions were put in there to be health protective and help support EPA's conclusion that this is a level that would not be associated with public health effects of concern. One other point, just a technical one, the level 18 micrograms per liter is the level that would avoid a 1%.
I'd like you to explain that because you say that several times in your brief, avoid a 1%. How is it an avoid? I thought these are levels that are associated with a 1% drop, which implies that it causes it, not that it avoids it.
The idea is that if we were to regulate at that level, it would avoid that 1% effect. It would avoid that one.
Why? Because they're allowed to be at that level. That's the maximum level.
That's the maximum level goal is let's have that or less. Yes. And so if you had that or less, it would avoid a 1% IQ effect.
But they can go right up to that, which would be a 1% drop. They can go right up to 18 if that's the level, right? So that is associated with a 1% drop. If you're setting a maximum limit, you can't assume that everybody following your regulation is going to be way below it. You're going to go right up to what you're allowing.
Your Honor, one quick point just about MCLGs versus levels that they would have to comply with. MCLG is the goal, and then a regulatory level can be set higher than the MCLG. But in any event, here the question was if there's perchlorate out there in drinking water systems at 18 or higher, are we concerned about that? Is that a level of public health?
I understand, and at 18, it's associated with a 1% drop in IQ, so I don't see how that avoids a 1% drop.
I think, again, it was because if you regulate that level, it would avoid it. It was the terminology that the agency used. The court has no other questions. I see my time is up.
All right, thank you. Ms. Snow.
Good morning, Your Honors. May it please the court.
Good morning.
Fran Snow on behalf of Interveners American Water Rights Association. I'll
I'm
start-
sorry, could you speak up a little, please?
Yes, Your Honor. I'll start by discussing the authority to withdraw a determination. I think an important distinction here, Your Honors, is this is not a regulation. It's a determination. That is a preliminary step towards regulating. And Judge Tatel, I just wanted to clarify that because in talking about some of the case law earlier, you mentioned inherent authority to withdraw a regulation. And here we have what is clear in the statute to be a preliminary step towards that. Judge Pan, I think you have the absolute right reading of the statute here for that reason, that the provisions that would require a regulation are, or the provisions say when you have a positive determination, then there is a requirement to issue a regulation and to do so on a specific timeline. But when you no longer
But
have.
the statute says, hold on a second, okay? It says,
So this is in the statutory
it
addendum
says
at
that,
17.
that once the determination is made, the agency shall regulate, right? That's what it says. It says once the determination is made, I'm not quoting the statute, but it says shall regulate.
Your Honor, it
It
says,
doesn't say, the next sentence says shall issue a regulation within a certain number of years, but it does say determination is made, it shall regulate. Isn't that what the statute says?
it says for each contaminant that the administrator determines to regulate.
Yeah.
And here we no
Makes a
longer have that
determination,
positive.
makes a determination, it shall regulate.
But here we no longer have that positive determination. And I think, Your Honor, the more important piece here to fit into that is the 3 statutory criteria for regulating have to be present at the time of regulation. If EPA determines that those statutory criteria are not present when it goes to issue that regulation, it cannot issue a regulation. And so it cannot be that this determination is the final question, especially because we know that Congress specifically added these 3 statutory criteria out of a concern with overregulation of substances that just weren't occurring at frequencies and levels of public health concern. It would make no sense for Congress to have added those 3 statutory criteria and then not give the agency the ability, when it went to issue that regulation, to withdraw that determination. So I do think Judge Pan has the best reading of this statute, that there is a requirement as long as there is a positive determination. But if there's no longer a positive determination, then there's no longer a requirement to issue a regulation.
And do you have an opinion about deference to the agency on this?
Your Honor, I don't think we believe that you need to have deference to the agency on its interpretation here, because I think it's clear from the statute that you have to have those 3 statutory criteria. But you certainly could defer, because this is how EPA also explained why it was withdrawing its determination. And again, I think Congress would not have thought that they needed to say anything different about this, given that this was just meant to be a preliminary step towards regulation, and regulation would then occur on the basis of those 3 statutory criteria. Judge Pan, I also just wanted to address your concern about the proposed levels that EPA is talking about here. So again, unfortunately, the science is quite complicated in a situation where you don't have a binary good IQ, bad IQ. It's not the same as, are you sick with this, are you not? And so the agency had to take a number of steps to try and correlate what we do know about perchlorate and iodide inhibition with any possible neurological impacts. So unfortunately, there's not a smoking gun study here that shows that perchlorate in drinking water at these low levels corresponds to any specific neurological impact. What we have instead is knowing that perchlorate, given at very high levels in medical doses, impacts iodine intake. And we know that that can lead to impacts of iodine deficiency, and we know that those can lead to impacts on maternal hormones. We know that that can lead to neurological development issues. So the agency was trying to connect all of these dots and pick numbers that they could then use to look at the occurrence data we have for the public water systems and determine if there was going to be a meaningful impact or opportunity for national regulations to have a meaningful impact. Now, what we know and what's in the record is not just that EPA looked at these 3 levels, that they picked as ways to correspond the best version they could of figuring out whether or not there'd be a health impact at levels of perchlorate. But we also have all of the data from the national survey that EPA did under UMCR 1, where we know that perchlorate, even at the lowest levels of detection, was still showing up in less than 2% of those surveyed results. So the agency had before it in the record evidence not only at these 3 levels, but evidence of the overall level of happening in our water systems. And I think that's important because these statutory criteria were meant to address not just levels, but also levels of occurrence. So here we know that only, based on EPA's record, only 15 water systems out of more than 62,000 around the country. This is about 0.02% of the water systems would have perchlorate at these levels that would need to be regulated.
We didn't get a chance to address this with the EPA, but they, in determining what the prevalence was, they apparently updated data from 2001 to 2005 with more recent data from California and Massachusetts, but only replaced the samples that were positive for perchlorate. Why didn't they replace all of the samples from California? Why did they focus only on the ones that were positive for perchlorate? Because the claim is that that biases the data.
So, Your Honor, first, I just want to point out that you can look at also within the record, the 2008 determination where EPA didn't remove any of these samples, and they came to the exact same conclusion. Removing these samples really didn't move the needle. Even there, they said less than 1% of water systems in this country had perchlorate at levels there. They looked at 15 parts per billion, which is even lower than the levels they looked at here. So again, we're talking about a very, very small percentage.
So what happened in 2008?
That was when they made the preliminary determination not to regulate perchlorate. So EPA has reached the same.
But they use the UCMR?
They use the UCMR, so exact same set of data without removing any of these samples, came to the same conclusion, again, found that less than 1% of our water systems had perchlorate, even at their 15 parts per billion, so lower than the 18 parts per billion that they used here, and determined that regulation, they made a negative determination, regulation was not warranted because of the very low levels of occurrence happening around the country. As to the specific pieces of data that they removed here, so EPA actually used neutral criteria in what they were doing. They did a couple of things. One, where there was updated information from the states that now regulated, indicating that there were no violations of those state regulations, which I believe California's is a 6 parts per billion. Then they knew that those water systems no longer had those elevated levels of perchlorate, and so they updated based on that.
They selectively updated, correct? They only updated the samples in the UCMR that were positive for perchlorate. Why did they just replace all of the California data with the new California data?
Your Honor, I think because state regulation would have required all of those water systems to be below that level, right? So we know that those water systems no longer have the elevated levels. But again, I don't think that's something that this court needs to get into, because within the record that was before the agency, they again had all the data showing that even if you used UMCR 1, even if you didn't remove any of those data samples, you'd get to the same place. perchlorate is, and this is good news, Your Honors, perchlorate is not occurring in our water systems at levels of public health concern. That should be something that everybody feels very good about, because there's certainly a number of other issues.
Issue in this case? That's what your position is, but they don't seem to think so.
Understood, Your Honor, but we also have a statutory scheme where the third factor is that this has to, in the sole discretion of the EPA administrator, provide for a meaningful opportunity to impact the public health concern. I completely understand why it makes everybody uncomfortable to talk about drops in IQ. And we recognize that iodine deficiency is a real public health concern, but based on the record before the agency, Safe Water Drinking Act regulation doesn't provide a meaningful way to address that public health concern. I'd say a good example or analogy that the EPA has dealt with in the past is sodium. Sodium is ubiquitous in our drinking water, and we know that sodium can cause heart disease or stroke, but EPA came in and did an analysis and found that the contribution of sodium to the health concern was just not a justification for regulating of our public water systems. Again, Congress introduced these three statutory factors out of a concern that when we add substances to Safe Drinking Water Act regulations that just aren't at national frequencies, then frankly, what we're really doing is overburdening our public water systems and distracting from their ability to monitor and come into compliance with more pressing health concerns. That's exactly why the statutory scheme was put in place. And that's really the issue you would have if you were to force the agency to regulate perchlorate here, because the record shows that it is just not occurring in our public water systems at levels and frequencies on a national basis that would allow for there to be a meaningful opportunity.
Excuse me, NRDC says in its brief that that since the passage of these amendments, the 20-some years since these amendments were passed, EPA hasn't issued final regulations for any contaminant. Is that true?
That's correct, Your Honor. There are about 90 contaminants that are listed right now. EPA goes in by statute every 5 years and has to consider 5 additional contaminants and whether or not it's appropriate to regulate those. EPA also has to come in every 6 years and look at the contaminants that are already being regulated and determine if they should make the regulations more stringent. So there's certainly plenty that's happening under this statute, but thus far EPA has not determined that there was a reason to regulate additional substances outside of those original 90.
Any other questions?
No.
Thank you very much, Ms. Snow. Ms. Fort, you have 2 minutes.
Right, Your Honor. So there's a lot that's been said. I'll try to get to as much of it as I can. On the occurrence analysis, Council's numbers assume that EPA undertook a reasonable update. And the reality is that the agency didn't. The agency only went back to 2 states, the 2 states in the nation that are the only 2 places that have since regulated perchlorate. And within those 2 states only went back to places where perchlorate had previously been detected. Of course, those sites have gotten better. We know there's a problem, and the states have since regulated it. That says nothing about what is happening on a national basis and is absolutely not a reasonable basis for the agency to decide that perchlorate is getting better. I will also say that it is not safe to assume that because the other places are subject to state regulation that they are necessarily in compliance. EPA's own brief at page 51 shows that California has detected perchlorate exceedances in 11.4% of large public drinking water systems between 2007 and 2018. It's simply not true that this is a problem that has been solved. I also want to go back to the EPA's point that this is about a model. This is its scientific analysis. We're not challenging the model. We're not challenging the agency's scientific analysis. The agency itself described the levels that it selected as a policy decision. EPA says there's nothing in the record to suggest that a lower level should have been selected. I'll refer the court to JA 743, which is EPA's own response to a comment from AWWA, in which it says, small changes in IQ become important when considered on the population level. For example, one study argues that although a 1-point change in IQ is within the standard error of an individual measurement and would not be regarded as clinical disease, it is still highly significant on a population level. That is completely inconsistent with the statutory command that the Safe Drinking Water Act has given EPA. I'll refer the court on the question of whether it avoids IQ loss to 84 Fed Reg 3557 Note 1. And finally, Your Honor, EPA on the reconsideration point, EPA is trying to preserve its authority to resolve a situation that is entirely hypothetical, the possibility that there might someday be a contaminant on which there is a dramatic change in science. It is failing to respond to the actual problem that Congress was trying to address, which is that there are a number of contaminants out there that we're not testing for, that people don't know if they're in their public water, and that are causing real harm to public health. And that is the problem that Congress was trying to solve. And that is why Congress said, once you make a determination that it meets that criteria, we're going to hold you to it. And we're going to make you actually protect public health, which is the purpose of this statute.
Thank you.
Thank you, Your Honor.
The case is submitted.
There goes the crowd.
Yes.
Case number 22-7060. Elsa Maldonado et al. Appellants versus District of Columbia, a municipal corporation. Mr. Huang for the appellants, Mr. Lau for the appellate.
Good morning, Mr. Huang.
Morning.
We are ready when you are.
May it please the court. My name is Michael Huang from the firm Terrace Pavlik and Million, and I represent plaintiffs' appellants. I'd like to reserve 1 minute of my time for rebuttal. This appeal may be decided by a basic principle. The case can't be moved if the violation alleged by plaintiffs is ongoing, as this court said in Chew the Vote versus IRS. Plaintiffs brought this case to require the District of Columbia to provide procedural due process to plaintiffs in the form of individualized written notice when their prescriptions are denied at the pharmacy. The district had a heavy burden to prove lewdness, and it failed to do so because it could provide no evidence that its violations had actually ceased.
Well, just hold up just a minute here. The case was brought alleging that they did not have in place regulations or procedures or processes that would ensure that people got this notice of what their right was to appeal and related rights. They have issued such a directive to all the participating pharmacies, have they not?
Your Honor, the district's entire argument rests on the idea that plaintiffs only...
So that would be a yes, right? They have done so?
Well, plaintiffs' factual allegations were that the district had no policies, procedures, or practices. Plaintiffs specifically identified...
But as far as practices, what you're talking about in practices would be a violation of what they have directed their pharmacies to do, right?
Well, it would be implementation of their policy, their paper policy, I would add.
So the remedy for that would appear to be that if there are individual cases where they're not doing it, that would be for action in those individual cases, and that this class action to correct the failure to so direct is moot. If they've done what they were ordered to do.
No, Your Honor. Policy, in our view, is neither sufficient nor necessary If plaintiffs only challenge the district's policy or the lack of a policy, then the district would be correct that the fact.
Normally, it's stated many times in various cases that you cannot enjoin someone to obey the law. They're already compelled to obey the law. As far as if all you're doing is telling them, don't violate this, then it's not a proper case for equitable relief. It's a proper case for individual administrative relief, isn't it?
Your Honor, I believe that what the cases say is in a case of this nature that the issuance of a policy does not automatically moot a case.
Generally speaking, you cite the vote case, vote now, I think it is. But in those cases, in that one at least, the agency was actually, you started with a classic injunction, quit discriminating, okay? They had said, okay, people on our staff quit discriminating, but there was clear evidence that they were still discriminating. There was an affirmative act going on. Here, there's not an affirmative act you're trying to stop. There's a failure to act that you're trying to start. And I'm not sure how we can do anything at this stage to remedy that. That appears to be something you'd have to do in an individualized action.
We disagree, Your Honor. I mean, you're absolutely correct that this case is very different from the situation where you're asking a defendant to stop doing something.
Yeah.
I mean, here we're alleging the deprivation of a right, where the plaintiffs have alleged
here you're wanting the
deprivation of due
agency
process.
no, you're wanting the contracting parties to start doing something.
Right.
And I'm not sure what more we could order the district to do when they've already told their pharmacists, you have to start doing this.
Your Honor, what plaintiffs alleged in their complaint to be the unlawful conduct was the failure to give plaintiffs procedural due process. So
yeah, right.
It's
right. So now when we get to the stage where you can determine whether or not they're getting the process,
correct.
We've done what the court can do on that, haven't we? What further?
No.
We can't go out and look in the drugstores and see whether they're failing to do that. Doesn't that require an individualized action?
Your Honor, the district simply issuing a policy on paper does not give plaintiffs procedural due process.
What did they fail to do?
They had, when the case started in 2010.
No. Forget about when the case started. When we come now and the district court has said it's moot, what is it that you say the district could have done that they haven't done?
The district could have awarded much more injunctive relief.
Could have done what? I'm sorry?
It could, much more injunctive relief, Your Honor. It could have required the district to do monitoring of its policy. It could require the district to actually give the notice by training the pharmacies. It could require funding of the implementation of a program to give individualized written notice. There's many things that the district court was empowered to award as far as injunctive relief. Beyond even the injunctive relief, there is also the availability of.
So you would say that an action to enjoin them or mandatorily enjoin them from something they've not been doing would empower the district court to take over and run the district?
Well, that's not what plaintiffs are saying, but as a practical matter, it would be incumbent on the district to decide how it wants to.
How can we draw an order that says it's incumbent upon you to decide how to do this? But you're to do it, but it's incumbent upon you, and we're not in a position to tell you.
Well, Your Honor, it would be inappropriate for plaintiffs.
Why is it not appropriate for the plaintiffs who, if they are actually not getting their process, to go to court and ask for their process? Or first demand it of the district, and then if they don't get it,
Your Honor,
why is that not the appropriate way to proceed?
Your Honor, we don't believe that's what the cases require. There's cases, including from this circuit, such as Zuckerman and True the Vote, which say that just because an agency has ostensibly changed its policy, that is not enough.
But True the Vote, again, that's where the IRS had claimed that they had quit discriminating, and then in the further proceedings after the district court admitted that they still had people discriminating. We were not there ordering them to go out and do something. We were ordering them to quit doing something. And as you admitted earlier in your argument, it's the opposite of what we're asking for here.
Your Honor is correct, but we believe that the fact that the district is required to take affirmative steps to do something and sustain that in perpetuity, that makes this case even harder to moot, because the district is required to take affirmative action That requires resources, that requires effort. And so if the court were to, for example, apply the test for voluntary cessation, then that suggests that the district's violations would not be unlikely to recur. But we think that, as To the Vote says, that the court doesn't even need to get there because the district simply hasn't even shown, it hasn't met the threshold issue of showing that its violations have
To the Vote is not in point. To the Vote is an opposite situation. You had that there admitted that the IRS were discriminating against certain employer in certain entities as far as the tax deductible status.
Your Honor.
The IRS claimed, all right, we told our people to quit. But it came to court and they admitted they hadn't quit. So we said, look, it's not moot because they're still doing it, so quit doing it. That was very simple. This is not at all the same thing.
Your Honor, we would submit that this case is exactly like that because even though
no, it's 180 degrees off.
Well, it's the same as To the Vote in the sense that plaintiffs came forward with clear, unrebutted evidence that violations are ongoing. And this again.
In which case, the violations are a failure to do something. In To the Vote, the age of these violations were doing something. It's 180 degrees different. It's what the mandatory power, the injunctive power would have to be.
You're correct, Your Honor, that the injunction that would be awarded is certainly different. But we think that distinction actually works in our favor as far as considering the mootness question. It is much easier for a defendant to stop doing something. Most of the time, it's going to be costless. In this situation, the district was required to come forth with specific facts to show that due process violations actually ceased. Plaintiffs did not.
How can you ever come forward with acts to show that this isn't going to happen again when the thing you're talking about not happening again is an affirmative act? That you lost me here. How you think this is in your favor?
Well, Your Honor, the well-established standard for determining mootness in a situation like this is voluntary cessation. This court said cessation is not near cessation. Case is not moot if it's moot as to the vast majority of parties. So cessation, by definition, that means to bring an end to something.
Yeah.
It is difficult, Your Honor. Conceitedly, it would be difficult for a defendant to show mootness, but that is as it should be because mootness would deprive the court of subject matter jurisdiction. So for the district court to decide at the motion to dismiss stage that this case was moot without requiring the district to come forward with specific evidence showing that its due process violations had ceased, we submit fell far short of the standard.
How can you ever show that? How could they ever show that they've totally ceased?
The district?
Yeah, how could they ever show that? They go out and say that there's not any out there today. We went around all our apartments and said, have you violated today? Or is this? It
would be very hard for them to show it in a pre-discovery stage, Your Honor. They would have to come forward with evidence that they were actually giving notice, that they had policies, practices, and procedures to ensure that plaintiffs were actually receiving due process. So that is what we submit that the district could have done, should have done. Any defendant in a case such as this would be required to do in order to prove mootness. It is appropriately a high bar. It is a high standard. And plaintiffs, even though the plaintiffs were not allowed to take discovery and did not have the burden of proof, came forward with unrebutted evidence to show that the district's due process violations are ongoing. I see that over my time.
Do you have any questions, Judge Tatel? Thank you, Mr. Hall. We'll give you some time on rebuttal.
Good morning. May it please the court, Richard Love for the District of Columbia. The district already has a notice policy that the district court found satisfied due process. And plaintiff's arguments here are based on a different case. The challenge.
Why is the policy enough when the allegation is that there's a deprivation of due process at the counter when people are trying to purchase their prescription drugs? Why is the policy enough? Why are you not responsible for ensuring that the policy is implemented?
Well, I think it's not enough because the claim that the plaintiffs have brought, and this is consistent in all of the complaints from the original complaint, the First Amendment complaint, and the Second Amendment complaint, as well as in their other motions that they have filed before the court, is based on a failure of the districts to have a policy, a transmittal, a regulation, or any guidance that provides for individualized written notice at the point of sale when a Medicaid prescription is denied.
Paragraph 1 of the complaint says that the district's policies, procedures, and practices of failing to provide individualized notice violate the due process clause. I mean, that sounds like the allegation is that they're failing to get notice. And then they go through several paragraphs in the complaint, 44 through 57, where Maldonado herself alleges that she was repeatedly denied a Medicaid prescription without notice. So the allegation isn't just that there's an absence of policy; it's that they're in fact not getting the actual notice when a prescription is denied. That's what the complaint says.
Well, I agree, Your Honor, that the injury that they assert is that they don't receive written notice at the point of sale when their prescription is denied. But the moving cause of their violation has consistently been the lack of a district policy.
No, I just read you from the complaint that their allegation is that they're actually not getting notice, and also in our earlier decision in this case, one of our earlier decisions in this case, NB, we described the district's the plaintiff's allegation as the district, quote, systematically failing to provide Medicaid recipients with actual notice. And that was the basis for their Article 3 standing in that case.
I think
so. You've got the complaint saying they're being denied notice. You've got our earlier decision saying they're systematically denied notice, and that is the basis for the Article 3 injury. So I don't see how you can say that the only thing they're seeking is a policy.
Well, I think that the basis of their claim was that the lack of a policy.
Well, their complaint was, the district doesn't have a policy, and we're being denied the information required by the due process clause.
I agree.
Of course, they argue both. Now you have a policy, but they still have evidence that they're in fact not getting the required the notice that they believe they're entitled to under the due process.
I agree, Your Honor, that as I said, the injury is their failure to receive notice, but the moving cause, the original theory of this claim has always been a lack of policy or procedure that required it. And in your decision in ND1, the court found standing that plaintiff had alleged a procedural injury, and I quote, that was directly traceable to the district Medicaid agency's failure to establish policies and procedures for providing the required notice.
Yeah, exactly.
And procedures.
And now
Counsel,
that's
these are
exactly what the
individual.
district has done.
Counsel, excuse me. These are individual plaintiffs. What good is a policy to them if it's not being implemented? If they're not getting the notice that they're entitled to under the due process clause at the point of sale, what good is a policy that's not being implemented to individuals standing at the counter?
Well, I would submit that there's not evidence that they're not getting the policy, particularly.
Well, to the contrary, apparently there is evidence in the record that they're not getting it in 13 out of 16 pharmacies that they surveyed. But if we disagree with you, if we find or hold that the plaintiff's claim was not tied strictly to policies, then do you agree that you would lose this case and this is a remand?
Yes, Your Honor.
Thank you.
I would submit, however, at a minimum, the policy portion of this claim is moot. We have a finding by the district court that the policy satisfies due process. It provides it's constitutionally
Why would we have to
sufficient.
decide that? We would just remand this and then
Well,
there would be
I
further
would-
proceedings. Why would we hold this partially moot? That makes no sense.
Well, I think it's important for the court to be clear on what this is being remanded on. And this is a municipal liability case. It was originally premised on a lack of a policy. Now it's a practice case. But we don't have evidence. We don't have factual allegations in the complaint that this there's a practice of violating the current policy that is so widespread, egregious, and persistent as to be a standard operating procedure of which municipal policy.
Would you be in a better position on that argument if the district court had permitted discovery instead of granting summary judgment?
Undoubtedly, Your Honor, but my suggestion simply is if it's remanded, it should be remanded on the sole remaining issue, which is whether or not the district has a practice of violating the 2020 policy. In other words, that policy is violated,
So are you conceding that the case should be remanded then?
No, I'm saying at least, my original argument haven't changed. The question was if you don't accept that this is tied to a policy with, what would be the repercussion? Yes, I think the court would then have to remand. But as I suggest, I think the policy portion of this claim is moot, that it is important to find that the district court, and it hasn't been challenged.
Do you have
here
any
on
precedent
appeal.
for us doing a partial remand like that, holding part of the case moot and remanding the rest?
Well,
I don't see why we would do that. If there are going to be further proceedings in the district court, we should just remand for further findings consistent with whatever we say in our opinion. Do you have any precedent for us doing what you're proposing?
Well, I do think we cite precedent in terms of that the court's finding that the notice that the policy requires is constitutionally sufficient is law of the case. And it hasn't been squarely challenged in this appeal.
Well, that would be up to Judge Leon.
Excuse me?
It would be up to the district court on remand to determine that.
Well,
I'm curious about your character a few questions ago. Excuse me, you said there wasn't any evidence that people aren't getting notice, and the district court said there was only a handful of them. But let me just, here's what the plaintiffs say they found in their survey. Non-compliance with the transmittal memo in all 8 wards. Only 3 out of the 16 pharmacies only 3 of the 16 pharmacies said they were getting notice. And that Medicaid recipients, including the named plaintiffs in this case, were denied Medicaid coverage without any notice. That doesn't sound like, I mean, they haven't even had any discovery. And this is, and they also say in their brief that the district didn't challenge any of that in the district court. Is that correct?
well, no, the district didn't challenge the BR's affidavit declaration, which is the only competent evidence in the case. And it said it really couldn't address the hearsay declaration as to what the various pharmacists hold.
Well, but this evidence is unchallenged, at least at this stage of the record. So it's a little hard for me to see how you could characterize this. Or do you agree that this is, quote, a handful of examples?
I didn't mean to, if I...
No, that was a district judge who said handful. I was asking if you agreed with him.
I think there are sporadic instances of non-compliance. After all, there are hundreds of pharmacies, hundreds of prescriptions.
Non-compliance in all 8 wards of the district.
Well, we disagreed with that interpretation as we set forth in our brief. I think if
You disagreed in your brief, but you didn't disagree in the district court. And the plaintiffs hadn't had any discovery.
Well, I'm not putting forth evidence. I'm simply saying that I read those declarations that at least 9 of those pharmacies provide notice in some form, whether through an insurance form, a text, or an email. And in terms of whether there's notice provided constitutionally, that is sufficient, whether it's provided through the district's required notice form or some other notice form.
By the way, just in terms of your argument that the policy, your basic argument is still, look, we've issued a policy that answers the complaint, right? case is moot, right?
That's the original claim. The policy is.
Suppose after the Supreme Court decided Brown versus Board, the states had simply passed laws saying no more dual system, period. You think that would have made Brown moot?
I think it depends on how the complaint was filed.
Just like this case, the students are claiming that they're denied admission to white schools. So the state passes a law saying anybody can go to any school they want. And the plaintiff says, wait, we're still being denied admission to those schools. Under your theory, it would be dismissed, correct? Because the states have a policy.
I think the difference in this case, Your Honor, is that this is a municipal practice case. And to show municipal liability, you need to show either a policy or practice that's a moving cause of the violation. And here, the theory.
I'm sorry, so the Brown v. Board case would not be in a similar posture?
I'm sorry?
Judge Tatel asked you a hypothetical involving Brown v. Board, and that's not a municipal practice if children are denied entry to.
No, I agree. I'm not disagreeing with, no, it would not be moot. I'm simply pointing.
Then I don't understand how this case is moot. It's the same case, exactly the same.
Well, Your Honor, I think as I put forth, we believe at minimum the policy issue is a moot issue, and if it were remanded, it should be
Counsel,
remanded.
the issue before us today is based on a summary judgment on a jurisdictional question. That is to say whether the case is moot or not. Now, under Herbert, district courts can and in times must have evidentiary proceedings with respect to the jurisdictional facts on which a jurisdictional decision is made. So why would it not be the case that at least the district court should have permitted the plaintiffs to go forward with discovery to answer the mootness, to answer the jurisdictional question in the Victor Herbert type hearing?
I think that the court didn't abuse its discretion in not allowing discovery because I think the discovery that the plaintiff requested really went to the implementation of the 2020 policy and not the constitutional sufficiency of the policy. And certainly it could have authorized.
If the question is open, and if you look in the original complaint, I will grant you that the amended complaint is principally directed toward policy, but they do have the words practices in, the magic words from the municipal liability cases are in there, aren't they?
Yes, they are.
Okay.
But I would submit that the practice is
So now-
failure to have a policy requiring individual notice.
So now, though, once the question has become mootness, why shouldn't they be entitled to at least attempt to show facts from which the court might determine that the practices do not match the policy?
I think that raises the question whether the district court abuses authority in denying it. And as I said, I
Well, you don't really have discretion on a summary judgment. You have to conclude that there's no substantial question of material fact. That's not a discretionary question. That's a question of law. Well, the abuse of discretion is not the standard on summary judgment, is it?
No, but
No.
it would be on whether or not the district court did not allow that the type of discovery that you suggest should have been allowed to determine whether there was jurisdiction.
Now, again, normally we would think that the lapse of time here would say, well, they should have got it done before summary judgment. But the mootness question didn't come up till this stage, obviously, of the litigation. So, again, maybe apply abuse of discretion even then and say, shouldn't there have been at least an allowance of an attempt to show that the practices were not meeting the standard?
I certainly think that the court could have authorized that discovery, but I don't think it abused its discretion.
Thank you. Anything else? Thank you very much, Mr.
Thank you.
Mr. Huang, we'll give you 1 minute. Mr. Huang, if you could address your motion to remand to a different judge. We haven't had a chance to touch on that.
Yes, Your Honor. Put simply, this case is over 12 years old and plaintiffs have never been to discovery. I'll note that in 2012, when we were before this court and the case was remanded on standing, this court wanted the case to proceed to the merits. Regretfully, we have not been able to proceed to the merits in the over 10 years since then.
It has to be truly extraordinary under our case law for us to do that. And what's your best argument for why this is truly extraordinary?
Well, we believe that fact itself is extraordinary. It's not usual for a case of this nature to have gone 12 years without discovery. But beyond that, it's the way that the district court has adjudicated the merits of plaintiff's motions versus the district motions has not been fair. The district court has refused to adjudicate plaintiff's motions for class certification. The rule for class certification states that those motions should be adjudicated at the earliest practical stage. The district court has refused to adjudicate plaintiff's motions for summary judgment. And on the other hand, the district court has entertained motion to dismiss after motion to dismiss filed by the district, which has resulted in 3 trips for this court. So it is the unequal treatment, and plaintiffs have essentially been unable to prosecute their case. They've been prevented from doing that. Discovery has been stayed. Most of the entire case, plaintiffs haven't had the opportunity to take discovery. And so because of those facts, plaintiffs believe that reassignment is appropriate.
Thank you. Any other questions? No. Thank you very much, Mr. Huang. Case is submitted.
Case number 21-5003. Adil Mohammed Abuzeid, MD, and Melissa Ann Abuzeid, appellants, versus Alejandro and Mayorkas, Secretary, U.S. Department of Homeland Security, et al. Mr. Schmidt for the appellants, Ms. Holsterberg for the appellees.
Thank you. Mr. Schmidt, we are ready when you are.
Good morning, Your Honors. May it please the court, Brian Schmidt on behalf of the appellants. The central question on review in this case is whether 8 U.S. Code 1252A2B prohibits judicial review of an affirmative adjustment of status application, where said denial is based on a misapplication and or misapplication or misinterpretation of another federal statute. In this case, 8 U.S. Code 1182E. By way of background, Dr. Adil Abuzeid entered the United States in J-1 visa status to complete a medical residency. On admission, he became subject to a requirement to return to his home country of 2 years. In this case, there are 2 home countries, the United Kingdom and Saudi Arabia. The 2-year foreign residence requirement creates 4 legal disabilities that do not go away until the applicant or the exchange visitor fulfills the requirement or obtains a waiver of the requirement. And one such disability is on an application for adjustment of status or for permanent resident status in the United States, also known as a green card application. In this case, the USCIS denied 2 adjustment of status applications to want the fulfillment of the 2-year foreign residence requirement for 2 separate reasons. The first reason is the government held that his trips to the United Kingdom and Saudi Arabia were too short to comprise residence. So 8 U.S. Code 1182E requires for fulfillment residence and physical presence for an aggregate.
Before you get in too far into the detail, you have a limited amount of time. The first question is a legal one. Why doesn't Tatel case in the Supreme Court exclude what you're asking us to do here?
Yes, Your Honor. So so the recent Tatel decision out of the Supreme Court does not actually apply to this case because the court explicitly held that in an affirmative adjustment of status application is not subject to its holding. Only applications and removal proceedings where relief is sought.
What was before the Supreme Court in Patel?
What was before the Supreme Court in Patel is whether this statutory provision, 8 U.S. Code 1252A2B, precludes judicial review of discretionary determinations in the removal context where relief is sought.
Was that in a removal context in Patel?
I'm sorry?
Was that in a removal context in Patel?
Yes, Your Honor. He was put into removal proceedings and a removal order was issued in that case.
But the status we're interpreting here, doesn't it say regardless of whether the judgment, decision, or action is made in removal proceedings?
Yes, Your Honor. So that is one of the government's arguments, the statutory language. And I would say that that's a strange reading of the statute in that it disregards the title of the statutory provision, judicial review of orders of removal.
That
There's no judicial
that is not the way we read statutes.
I'm sorry.
I said that is not the way we read statutes.
Well, and it's not just the title, Your Honor. The word relief is actually used in three locations.
Judge Pan read you the language of the statute. We never allow a title to overcome plain language in the statute itself.
It's additionally in the text in two other locations relevant to this question. So it's the word relief is in the title. It's also in the subtitle of this particular provision. And there's also language.
There's another word that may be a problem for the regarding in the statute, and the Supreme Court was defined very broadly, wasn't it?
So regardless of whether the judgment, decision, or action is
regarding is defined in the Supreme Court decision as including anything leading up to, or Justice Gorsuch's dissent does a good job of dismantling it, but that's a dissent. It doesn't matter.
Yes. Any judgment regarding the granting.
Right. And so there's a distinction between adjustment of status application in the context of removal proceedings in that relief is inherently being sought, whereas in an affirmative adjustment of status application, there's no relief sought. It's actually an affirmative benefit application. USCIS is a benefits granting agency.
But I guess the issue is whether that distinction matters when the statute explicitly says, regardless of whether the judgment, decision, or action is made in removal proceedings, no court shall have jurisdiction to review any judgment regarding the granting of relief under Section 1255. So is that the only basis in which you try to distinguish Patel? The fact that was removal proceeding, this is not?
No, Your Honor. We have circuit decision law. 4 circuits prior to Patel have actually held that you can get judicial review in this context. When you're looking at
prior to Patel.
Prior to Patel.
Prior to Patel, except Patel doesn't explicitly overrule any of those circuit decisions because it did not apply to anything outside of removal proceedings.
The Supreme Court doesn't necessarily go outside its immediate case to explicitly overrule cases, does it, counsel?
So when the Supreme Court held that, this is only applying to in the context of removal, I mean, it's explicitly and expressly said that and went on to say that we're not doing this. And they also said that the holding a majority ruling, and Patel said, may have intended to foreclose review when it comes to any other case, such as in this variety. And if you look at prior Supreme Court precedent in Kukana versus Holder, a 9-0 decision, where they actually employed statutory construction prescribed by the Supreme Court in Kukana versus Holder, that there's a presumption of judicial review of when there's administrative action, and it takes clear and convincing evidence to dislodge that presumption. But in this case,
or presumably a statutory bar.
I'm sorry.
There's a statutory provision here that forecloses it. So does that take that outside of the context in which you're referring?
No, this is actually interpreting, Kukana versus Holder interpreted the neighboring provision. of the statute saying we require clear and convincing evidence, and the provision they're interpreting is actually broader than the provision at issue in this case. And they said they required clear and convincing evidence. And what the court has held in Patel is may have intended to foreclose. So that's like very far away from clear and convincing evidence. The dissent actually went on. So the majority opinion in Kukana actually, or I'm sorry, in Patel said that Kukana's rule was inapposite in deciding the case. And the dissent actually pointed out that employing principles of statutory construction, that there absolutely is an implication that review should be held in cases of this variety. So he looked at the statutory language, and he looked at the ruling of Kukana and said there should actually be review in this kind of case. Additionally, let me add that the federal government has been inconsistent in their position on this issue. They actually advocated for, in Patel, that this kind of question would be subject to judicial review.
No, I understand that, but then Patel happened.
Yes, sir.
Thank you. Any other questions from the? All right, thank you very much.
Okay.
We'll give you a minute for rebuttal.
Good morning, Your Honors. May it please the court, Carol Alsterberg on behalf of the United States. The district court got it right. The district court correctly read the plain language of the statute at issue 1252A2BI and found that in cases such as this, the USCA denial of an adjustment of status application is unreviewable. And then Patel happened. And as appellant even concedes, Patel has had a grave impact on the different definitions of terms that are at issue in a case such as this. The question of what judgment means has been defined by Patel. The question of what the term any means has been defined by Patel. And the definition of what regarding means has also been defined by Patel, such that the broad scope of Patel applies here. Patel's reasoning equally applies in cases such as this, regarding the denial of an adjustment of status application by USCA. Looking to the language in the plain text of 1252A2B1, as this court noted itself, that states it's regardless of whether the judgment, decision, or action is made in removal proceedings. That's the case here. And B1 states that any judgment regarding the granting of relief under section 1255, which is also the case here. Dr. Abuzeid's application was denied pursuant to 1255.
Sounds pretty straightforward. I think
Yes.
I understand your position. If you have anything to add, please feel free. Otherwise, I think you'd be free to rest on your briefs.
Nothing further to add.
Thank you very much.
Thank you.
We'll give you 1 minute, Mr. Schmidt, if you'd like to give us any closing thoughts.
Thank you, Your Honor. So just going back to the text of the statute, we have the title, removal orders, denials of discretionary relief, and then all of the text, and then point 1, and then 8 U.S. Code 1255. And in an affirmative adjustment of status application, there is no relief that's being sought. It's a benefit application. Moreover, there's no review under the statute. There's no administrative review. There's no, what the government's arguing here is there's no judicial review. But in the context of removal proceeding, there's a channel review. So we have review in the Board of Immigration Appeals, followed by particular circuit courts of appeal with petitions for review, and then discretionarily with the Supreme Court. And as such, we would argue, especially given the fact that Patel did not hold that the holding applies to this kind of case and it only applies to removal proceedings, and they expressly said so, we would ask that the court find that the issue of reviewability remains open for this court to decide, and that the decisions in the circuits on in the decisional law cited in support of our application have not actually been overruled. And for these reasons, we ask that we respectfully request the reversal of the district court's ruling.
Thank you very much, Mr. Schmidt. Case is submitted.